What's up, everybody? Welcome back into the episode of The Lawyer You Know. And we're diving back into the Kouri Richins case as some truly unbelievable news has come out about a very, very, very important witness for the state that connects so many of these dots, makes this case make so much sense, has recanted, changed their testimony, said that is not my testimony, what you've been basing such a huge part of your case on. And we know there's a lot of evidence against Kouri Richins. A lot of people out there think that she did it, think the state is going to go and be able to prove this case beyond a reasonable doubt. Will that change because of this witness? And did the prosecutors know about it? And if they did, what'd they do about it? And what should happen? Should there be some kind of sanction? And how severe should that sanction be? So many questions, so many things to get through in this video, hopping back into Kouri Richins. Make sure you guys hit that like button. Make sure you're subscribed to the page. Let's get to it. For those of you who don't remember or have forgotten who Kouri Richins is, she is the Utah mom who allegedly lost her husband in the middle of the night. He passed away. She has 3 little boys at the time. She writes a children's book about coping with the death of their father. She goes on local news channels and morning shows to promote her book, makes money off of her book, all while in the background, there's a criminal investigation happening, and eventually she gets charged with his death, poisoning him with fentanyl. Now, how did they know that? How did they connect those dots? There's quite a bit of evidence, from text messages to letters she's written way later on in the case, to her actions after his death, to prenup agreements, to things that the victim, her husband, said to watch out for, from potential attempts in the past to take his life. All sorts of evidence painting this picture. But the big connection is conversations between Kouri Richins and multiple other individuals with her attempts to secure fentanyl and other drugs at different times to use them to accomplish this goal. For what reason? Well, as is often the case, money being one of the very major motives in this case. So connecting that dot, that Kouri Richins was specifically looking for fentanyl and she was given fentanyl, then how important is that to this case? Somebody said, did he recant? Did he recant or did he walk the dog? It's a good question. It's a good question. So referencing Kouri Richins' attempts in the past to try and control, secure, change witness testimony. We did a video on that letter if you want to go back and read it. But we're going to take a look at 3 different documents here, breaking down exactly what happened, when it happened, how it happened, okay? And what potentially happens from here. Because we've got to figure out, what do we do now? The state definitely thinks they have the right person that ended the life of a father of 3 young boys, his family. They're all victims in this case. They deserve justice. The state believes they have the right person in Kouri Richins, and they want to get justice for the victims in this case. But you have to do it the right way. So what happens when something like this completely railroads your case as a prosecutor? Let's take a look. So this is a request for an order compelling disclosure of exculpatory evidence. Those words are never good to hear if you're a prosecutor saying, you have to, we're compelling you, forcing you to give up exculpatory evidence, because we all know, right? We all know you have to give that up. That's already what the rules are. If you're a prosecutor, you've got to turn over exculpatory evidence. You can't hide that. You can't bury that. You can't decide not to disclose that. You shouldn't ever have to be told to compel exculpatory evidence. Prosecutors say she mixed a lethal dose of fentanyl into his drink. Kouri Richins' housekeeper allegedly sold her fentanyl pills prior to husband's poisoning. Kouri Richins, the Utah mom who allegedly poisoned her husband with a fentanyl-laced cocktail. Prosecutors allege she gave Eric Richins a lethal dose of fentanyl on the night of his death. And you'll notice fentanyl is italicized, or they're making sure that they put extra emphasis on fentanyl every chance they get. Investigator, and these are all quotes from different news articles and documents they have in the case. Investigators now say a woman accused of fatally poisoning her husband asked multiple people if they could procure fentanyl for her. Prosecutors previously have said she acquired fentanyl through a woman who cleaned houses for her businesses both in the months before and shortly after her husband's death in March 22. A search warrant granted earlier this month, however, indicates investigators believe the woman was not the only person Richins went to for fentanyl. All these headlines stem from allegations that Miss Richins procured oxycodone and ultimately fentanyl from her relationships and connections with Carmen Lauber, Robert Crozier, Nick Bonsavage, and Susan Kohler. Initially, Ms. Lauber informed investigators that fentanyl was never procured. See her transcript. The investigating officer subsequently interviewed Ms. Lauber again on May 3rd. It was at that meeting when Ms. Lauber indicated that she got fentanyl from Robbie, who is Robert Crozier. Mr. Crozier was interviewed in May of 23. During his interview, he confirmed that he had sold fentanyl to Ms. Lauber on 2 occasions. Sometime in April of this year, Mr. Crozier was interviewed by 2 members of the Summit County prosecution team, prosecutors doing this interviewing, at a Starbucks in Salt Lake City. The prosecution team asked Mr. Crozier if he had sold fentanyl to Ms. Lauber. Why do you think they needed to go ask him again? Mr. Crozier told them he had not sold fentanyl. He specified that he had sold Oxycontin to Ms. Lauber on 2 occasions in early 2022. Crozier told the prosecution team that he met Lauber at the Maverick in Draper both times to sell her pills, which we'll see why that's important. The prosecution team asked why Mr. Crozier had previously stated he had sold Ms. Lauber fentanyl. Mr. Crozier specified he did not remember saying that he had sold fentanyl and told them he had been detoxing during that interview and was out of it. Now, many times if we're doing interviews like that as a prosecutor or law enforcement, you'll ask them, are you on anything? Especially if they're known, drug dealers or people that take drugs, and they might say yes, they might say no. Sometimes you can use it, sometimes you can't. So we have a scenario where they asked him questions, he gave answers, but he said, I was out of it. Here's my truth. By the way, this is April of this year. We are now in October. So quick math here. I'm not a math whiz, but 6 months ago. It's quite a long time in these cases. A lot has happened in 6 months. Mr. Crozier told the prosecution team that he was certain he had sold Ms. Lauber Oxycontin 30 milligram pills, also known as Roxy's or Roxy 30s. The prosecution team asked Mr. Crozier several times if he was sure, maybe trying to rehab his testimony a bit, which is okay in a conversation. And Mr. Crozier told them he was unsure. He was sure he sold her Oxycontin. Prosecution team has been aware of this exculpatory evidence since April of this year, so April of 2025. So let's talk about this for a second, okay? The fact that this witness is now saying he sold Oxycontin instead of fentanyl, does that mean Kouri Richins is innocent? Obviously not. She's presumed innocent, okay? They still can go forward and prove the case against her. This change does not prove that she didn't do it and they need to dismiss all charges immediately. But what it is, without a doubt, is inconsistent testimony. It's impeachment evidence against a very important witness against the state, not just this witness, but also Ms. Lauber. So it's impeachment evidence against multiple witnesses who said the fentanyl may have originated with Mr. Crozier. So regardless of if you think this is going to make you lose the case as a prosecutor, you without a doubt, with 100% certainty, have an absolute duty to turn this over to the defense immediately. And if you don't, you should be sanctioned as a prosecutor. The prosecution has been aware of this exculpatory evidence since April of this year. The prosecution did not inform the defense of this information. No press release was issued, no reports, nothing. The prosecution just kept quiet. That's why the defense was quoting all of those articles, because look, everybody's talking about this. Prosecutors have talked about this stuff. There's cameras in the courtroom. Everybody knows about the facts of this case, but somehow this one gets hidden. No press release was issued, no reports, nothing. The prosecution just kept quiet. In preparation for trial, defense counsel located and interviewed Mr. Crozier within the past 30 days. So the defense finds this out on their own by interviewing these witnesses, not the prosecutor. And I got to be honest, regardless of how guilty you think Kouri Richins is, this is exactly what you can't do as a prosecutor. Because if this is happening, now I literally, if I'm the defense attorney on this case, I can't I can't trust anything the prosecutor tells me. I can't trust anything they tell me about any witness. I can't trust it when they tell me, oh yeah, we did this or we turned that over. That trust is completely gone. I give them no more benefit of the doubt throughout the entirety of this trial. And we know the judge in this case. I think he is going to be pissed. Teddy said, why is the prosecutor acting like this? I cannot answer that question. I have no idea why. Because we're going to talk about it as we go throughout these documents. They still have a strong case. Just because this like drug dealer guy, right, has changed his testimony, you can impeach him as a prosecution and be like, you sold her fentanyl, didn't you? No, just Oxycontin. Well, you said you sold her fentanyl here. Well, I was detoxing, so I was out of it. Okay. Then you ask Lauber, did you get fentanyl from Crozier? Yes. And the jury gets to weigh the credibility and make the decision. You do not lose your case as a prosecutor because of this change in testimony. Is it bad? Yes. Is it something the defense is going to make a big show out of at trial? Yes, as they should. Can we trust these witnesses? They're not credible. That happens. There's very few perfect cases as trial lawyers on either side. There's ones you're confident in, and we get that. But there's very few perfect cases. You're going to have to deal with stuff. And this is just something the prosecutors are going to have to deal with. When you have drug dealers and ex-cons and, all these people in and out of prison, like we saw with Adelson's case, those weren't perfect witnesses. The defense was able to call them jailhouse snitches with their get out of jail free card. That's fine as a prosecutor. You know that's going to happen. You deal with it. You move on. You trust the jury to make the right decision. You don't bury very obvious Brady evidence. Now, this is defense attorneys saying this. So maybe the prosecutor will say, no, we did turn this over to you. We sent it to you in discovery. We sent you an email. You must have missed it. We apologize. It was buried in 1,000 pages, whatever. So we have to wait, kind of hear from the prosecutor to say, no, this is actually not what happened. And I hope that this is a mistake and not something that they buried. I filled up my water and I left it somewhere else, not in my office. Okay. It was during this interview that the meeting and the exculpatory information became known to defense counsel. So the other thing is prosecutors could say, and this could be true, right? Crozier never told us that. We interviewed him and he had the same exact story. And maybe Crozier is now changing his story now. So that's possible as well. But if this is true, that he actually said these things to the prosecutors in this case, and they did not turn it over, we're going to talk about some of the possible sanctions, and you guys are not going to like it. You're not going to like the possible sanctions here and what we do to protect criminal defendants against prosecutors and cops doing things like this. The prosecution is required to disclose to the defendant the following material on information directly related to the case of which the prosecution team has knowledge and control. Evidence that must be disclosed under the United States and Utah constitutions, including all evidence favorable to the defendant that is material to guilt or punishment. Their duty to disclose is a continuing duty as the material information becomes known to the prosecutor, because obviously the defense doesn't know what the prosecutor is doing every single day. Every second of every day, we don't know who they're interviewing. We don't know who they're talking to or what they may get their hands on, which is why you have that continuing duty as a lawyer. You must continue to produce those documents. Rule 3.8 of the Utah Rules of Professional Conduct prescribe duties specific to the unique role of a prosecutor. It requires a prosecutor in a criminal case to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigate the offense. The timeliness of the prosecutor's disclosure of exculpatory evidence is a matter governed by in Utah by our rules of criminal procedure. By rule, a prosecutor must make all disclosures as soon as practicable following the filing of charges and before the defendant is required to plead. The court highlighted the distinction between the procedural rule and its ethical counterpart. The requirement of timely disclosure is important. It is aimed at allowing the defendant to adequately prepare his defense. And our ethics rule has the same evident focus. Rule 3.8D of the Utah Rules of Professional Conduct requires more than just disclosure. It requires timely disclosure, not disclosure 6 months later after the defense found it on their own. That's not going to be appropriate timely disclosure. This distinction is critical because without its ethical counterpart, a prosecutor would rarely face a consequence because it could hide behind the wide latitude of continuing obligation provided by Rule 16, meaning, yeah, we always have to supplement discovery. We always have to continue to turn things over to the other side, and we'll get to it eventually. We've got a lot of cases, and we'll give this to you before trial for sure within the discovery period. No. That's not good enough. It has to be timely, especially if it's something this important. If the prosecutor's possession of exculpatory evidence is uncovered at trial, a subsequent admission of that fact may be somewhat mitigating at the sanction phase. But the admission is not itself a fulfillment of Rule 3.8D, duty of disclosure. If that were enough, the rule would be rendered practically toothless, meaning we need to have teeth to this. There needs to be a punishment if a prosecutor does this so that other prosecutors will not, and that this prosecutor will never do it again. As any savvy prosecutor could avoid any ethics violation by the simple expedient of an after-the-fact admission of a prior failure to disclose once it is exposed by someone else. Right. That's just logic, right? I don't have to explain that to anybody why we don't want to do it that way. It's like, okay, you got me. Here it is. Here's the document. Here's the interview. A prosecutor cannot conflate the Brady standard with the prosecutor's ethical duty under Rule 3.8D. The two standards are distinct. The question under Brady is a matter of due process, of whether the prosecution's failure to disclose exculpatory material so undermines our confidence in the verdict that we should order a new trial. I would argue this violates Brady as well. But Rule 3.8D's focus is different. It is aimed not only at assuring a fair trial, but articulating the standard for a motion for a new one, but also at establishing an ethical duty that will avoid the problem in the first place. So what they're doing is they're not just arguing Brady here. They're also arguing an ethical violation by these prosecutors. And in most jurisdictions, that opens up a wide door of potential sanctions. In stating that duty, our rule requires timely disclosure by the prosecution. That duty cannot be fulfilled by a prosecutor's mere admission of the existence of exculpatory evidence after a witness first uncovers it. In addition to the timeliness of the disclosure, the prosecution's state of mind relating to the disclosure is paramount in determining an appropriate sanction. Did they do this on purpose? Was it negligent? Did they want to bury it? Did they accidentally forget to put it with other things? Here, the prosecution failed to disclose evidence that not only negates Ms. Richins' guilt, but completely eviscerates the prosecution's own theory that Ms. Richins procured the fentanyl that ultimately killed her husband. So, does it eviscerate it? I think you could argue that. Are there other ways and contexts that you could use indirectly to prove Richins must have got her hand on this and used it, or whatever it was, she thought it was this, but it was actually this, or maybe he actually did give her fentanyl but confused it for OxyContin. There are all sorts of arguments the state can still make. But from the defense's point of view, this crushes their entire case. The prosecution's failure to disclose and continued concealment of, that's a big problem too, the continued concealment of exculpatory evidence that Ms. Richins did not procure fentanyl inflicts ongoing harm on Ms. Richins, the public, and the integrity of our legal system. Now, at least through these means, right? Through these means. This is precisely the type of misconduct Rule 3.8 was designed to prevent. By withholding this evidence, the prosecution abandons its duty to seek justice, undermines the assurance of a fair trial. No doubt, there will be an attempt to chalk this up to an oversight, perhaps as an oversight that should be excused as nothing more than carelessness. But this was not an oversight. This was a continuing and knowing concealment. It is not a blemish on the fruit. It is rot at the core, poisoning the whole harvest of justice. Covenants without the sword are but words. What does this mean? This means rules without punishments. If you break those rules are worthless. They're just words on a paper. So if people break rules, they must be punished. I think we all agree with that, right? Let me know in the chat. Do you agree with that? Do you agree that if we have all these rules and you can just break them without getting punished, like what's the point of the rule? I have kids. Anybody that has kids knows that too. If you say, don't do this or else, and they do it and they never get punished, what do you think is going to happen? Courts have long trusted the prosecution to discharge its duty without supervision. But when that trust is broken, when the evidence negating guilt is withheld, trust alone no longer suffices. In this case, words like timely and becomes known suddenly demand a deadline. Counsel moves this court for a standing order imposing a 3-day deadline on the prosecution to disclose the following to the defense: all evidence, including emails, text messages, phone messages, recordings, video footage, or any other form of correspondence involving the prosecution team or any law enforcement official and Robert Crozier, including correspondence about setting up a meeting and any sort of summaries of that meeting. This should be such an easy yes sanction from the judge. All notes, correspondence, or reports prepared by law enforcement officials or any other member of the prosecution team discussing Robert Crozier's interview in April and or any other dates. Obviously, yes, again. Any statements, recordings, reports, or notes in whatever medium, including emails and text messages that tend to negate guilt, again, should be an obvious yes. Furthermore, the defense respectfully requests this court to require the prosecution to disclose on the record or reduce to writing and provide the defense all oral statements discovered when interviewing witnesses that tend to negate guilt or contradict prior statements made by the witnesses. So why did you do this? So these are the sanctions they're asking for now. We're also going to read a reconsideration for bail, okay? A reconsideration for bail is going to be another sanction that they're asking for. But when it comes to possible sanctions here, and I'm not being dramatic, okay? If I was a lawyer in this case, I think I'd probably ask for them all and see what happened. But if it was negligent, it was an accidental non-disclosure, I would still ask this witness be struck completely, unless I feel like it would be good for my case, right? I don't know how good it would be. I would try to extend it to Ms. Lauber. All of the kind of drug dealers in this case for Kouri Richins, I would ask the court to completely strike all of that testimony because they're having conversations with these people. They're not telling us about it. People are changing their testimony. And I know it's a severe sanction, but strike all this testimony. That's what I would ask for. I would also ask for potentially dismissal of the charges. Brady disclosures, hiding evidence, if it's intentional at this point, right? If the prosecutors are intentionally doing this, ask for them to completely dismiss charges. Judge would probably say no to that one, and I would agree with that. Then you can ask for personal sanctions on the lawyers, basically. Fines, retake the bar, take some kind of class, be put on the Brady list. All sorts of things personally. If these prosecutors really did this intentionally, they need to personally be sanctioned. Some leeway potentially on really digging into this with the witness, explaining what happened with the prosecution, putting it out in front of the jury that the prosecutors tried to bury this. That could be a sanction of some sort to try to put that in front of the jury. There's a wide range of things you can ask for here as the defense if the court finds an intentional violation or even a negligent violation of Brady and discovery, frankly. So we're going to see here. This could be a very big deal. Now, do I think the charges are going to get dismissed? Absolutely not. Do I think that Kouri Richins is absolutely going to win now because of this? No, I don't think so. I think if I was the state, based on a lot of the evidence, I would still feel pretty confident, actually. The Brady list is a list of people that have violated this rule. It can be law enforcement. It can be government officials or prosecutors. It can be judges. So that the defense knows in future cases, here's what's happened before with these people. Here's who you're dealing with. All right. Now let's take a look at the affidavit of Robert Crozier, the witness in question. What does he have to say? My name is Robert Crozier, and I am currently residing in the Davis County Jail, located at 800 West Street, West State Street, Farmington, Utah. Okay. Once again, he's in jail. It's unfortunate, but if I'm the state, why do I care if this guy's flip-flopping his testimony? Why am I going to bury that? Why don't I just deal with it, right? Like, just like in trial, we deal with a bad answer that happens or a bad decision by the judge. The judge keeps a piece of evidence out we want to come in or doesn't let me ask a question I want to ask. Like, from my perspective, you just deal with that stuff as a lawyer. That's part of what we deal with every single day. I am over the age of 18. I have personal knowledge of the facts stated herein, unless otherwise so stated. I've been identified as a witness in the above stated matter. In that capacity, I've been interviewed on 2 separate occasions by individuals associated with the prosecution of Kouri, Darden, Richins. I have been told that the first interview was on May 4th, 23, It was conducted by 2 officers from the Summit County Police Department at the Davis County Jail. I do not know the names of the officers who interviewed me. On May 4th of 23, I had been in jail for a short time and was detoxing from drug use. I do not have any personal recollection of the details of that interview, although I have since been told that I agreed that I had sold fentanyl to Carmen Lauber in 2022 on 2 occasions. In early April of 25 of this year, I was asked to meet with 2 people from Summit County Attorney's Office. I believe that both individuals were prosecutors, and they told me they were prosecuting Kouri Richins. I believe one of them was Brad Bloodworth. I cannot recall the name of the other individual who was at the meeting, but it was a man with a beard. I was sober at that meeting and had been sober for over 3 months. That's an addition, and that's an RC, him signing it in legal documents. If you have somebody handwrite something in or cross something out, the person doing it that needs to agree to it initials it, right? We met at Starbucks Coffee in downtown Salt Lake City. I believe that it was Starbucks on 80 South Main Street, Salt Lake City, Utah. Mr. Bloodworth and the other individual asked me if I sold fentanyl to Carmen Lauber. I told them no. I sold Oxycontin to Carmen Lauber on 2 occasions in early 22. I told them I met her at the Maverick in Draper both times to sell her the pills. They asked why I had previously told officers that I sold her fentanyl. I told them I did not remember saying that and that I had been detoxing during that interview and was out of it. I told them I was certain that I had sold Carmen Lauber Oxycontin 30 milligram pills, otherwise known as Roxy's or Roxy 30s. They asked me several times if I was sure. I told them yes, I was sure I sold her Oxycontin. I was told at that meeting that I would be called as a witness in this case and that the Summit County Attorney's Office would be putting me up in a hotel near the courthouse. I certify that this statement is true, and that was on the 10th of September. That's pretty damning stuff for the prosecutor. Okay, this is another affidavit. It's another affidavit by Robert Crozier. In early 2022, I was contacted by my friend Nicole Cummings, telling me that a friend of hers by the name of Carmen Lauber was looking for some pills and would be contacting me. Soon after, I received messages from Carmen Lauber asking to purchase some pills. On at least one occasion, she told me she wanted Roxy 30s, and on at least one occasion, she told me she wanted blues. I understood this to mean that she wanted 30 milligrams of Oxycontin pills. So this is also interesting in that the different pills, different names, nicknames, are they getting confused? Does Lauber think that she's getting or fentanyl? Does Crozier think he's giving Oxycontin? Does Kouri Richins think she's getting fentanyl? Does she think she's putting fentanyl in? All of that can be confusing, but at the end of the day, we know he died from a fentanyl overdose. So can that be confused from each other? What are experts going to say? What types of arguments and defenses is this going to bring up? It definitely muddies the water and makes the state's case much more difficult to prove. Not impossible, but you must turn this evidence over. In early 22, I knew the term blues to mean Oxycontin. I did not associate the term blues with fentanyl until late 22. So is that going to be a distinction? I met with Carmen Lauber on 2 occasions in February of 22 at the Maverick in Draper and sold her Oxycontin. The first time I sold her 30 pills. The second time I sold her more than 30 pills, but I can't recall how many. These were the only 2 times I met Carmen Lauber. I did not know her before she contacted me, and I have not had contact with her since February of 22. I began selling fentanyl at the end of 22. In May of 23, I was arrested for possessing fentanyl and was in Davis County Jail. At that time, 2 officers from the Summit County Police Department interviewed me. I do not remember their names. I was very confused during this interview as I was detoxing from drug use and was very out of it. At first, I did not remember Carmen Lauber, but after they reminded me, I did remember that I had sold pills to her and that she was a friend of Nicole Cummings. I don't remember the details of that interview, but I have since been told that during the interview, I agreed that I had sold fentanyl to Carmen Lauber and that blues referred to fentanyl. It is my belief that I agreed I had sold Carmen Lauber fentanyl because I was personally detoxing from fentanyl during that interview, and by then had been selling fentanyl, which I had come to know as blues. So different context, different timing, different, words are important, definitions are important. We always say that. Yeah, I see some people talk about maybe he actually gave fentanyl pills. We don't know. And that's the point. All of this just becomes a little more confusing. a little more difficult for the prosecution. I'm currently in recovery, and although I have relapsed during my recovery. At this time, I've been sober for about 3 weeks. I thought before it said 3 months. Did it say 3 weeks? It said over 3 months here. This was dated September 10th. This was dated September 10th as well. A little confusing there. Prior to my relapse, I had been clean for 9 months. I did not sell Carmen Lauber fentanyl in February of 22, but sold her 30 milligrams of Oxycontin pills. In early 22, I was not selling fentanyl and did not have access to fentanyl. Rather, I was selling my own Oxycontin prescription, which were 10 milligram pills. If a buyer wanted stronger pills, I had a source who provided 30 milligram Oxycontin, which is what I sold to Carmen Lauber. Roxy's or Roxy 30 refers to 30 milligrams Oxycontin pills. To my knowledge, Blues also referred to Oxycontin in late 22 when I came to know the term as being used for fentanyl. I did not acquire a source for fentanyl until end of 22. The fentanyl pills that I began selling at that time were very dark blue, almost purple. In April of 25, I was interviewed by prosecution with Summit County Attorney's Office and told them I had sold Oxycontin to Carmen Lauber and not fentanyl. I certified that this statement is true. Doubling down, tripling down. Now, if I'm the prosecutor, I'm like, this guy keeps flip-flopping. We think the fentanyl story is true, but members of the jury, you tell us you believe, and we're going to give you all this other circumstantial evidence and all this other context to what he's saying. And even he admits he did call fentanyl blues at some point. He did sell fentanyl in the same year. It's like maybe he's getting his months screwed up. He will admit on the stand, my guess is his brain was a little scrambled when he was on these drugs, detoxing, getting back on them, things like that. I think you can deal with this person. I think you can deal with this person as the prosecution team, as the defense team, however you want to, right? And make your arguments. The real point of all of this is the defense must be told about this information. They must. All right, next up is the defendant's motion to reconsider bail and conditions of release. So this is an indication to us that Kouri Richins and her team are going to start asking for things now. They feel her rights were trampled on, her rights were violated, this was not fair, and now we need to go back, correct the record, and fix some things in the past that we did based on what the state told us, based on how nicely knit together they said this case was, based on how much evidence they told us they had in this case. Let's go back and reevaluate and see if that's actually true, or if we should reconsider some of the decisions we made based on that. Kouri Darden Richins, by and through undersigned counsel, hereby moves this court to reconsider setting bail and ordering conditions of release pursuant to these sections of the Utah Code, which provide in part that a party may move to modify a pretrial status order at any time upon showing that there has been a material change in circumstances. This motion is based on the following. The matter of bail has been brought before this court on 2 occasions. First, on June 12th of 23, this court conducted a detention hearing and considered exhibits, testimony, and argument submitted by the parties. I believe we watched that together. One of these we did. At that time, Ms. Richins was facing a potential death penalty on the aggravated M charge and was not entitled to bail as a matter of right. That's not the one we watched. The court did, however, go on to find that there was substantial evidence to support the charge and clear and convincing evidence that the defendant would pose a substantial danger to the community if released on bail. Maybe it was. I can't remember. At that time, the court made no findings of risk of flight. On October 22nd, 24, Ms. Richins, through counsel, filed a motion to reconsider, arguing there's been a material change of circumstances since the prior detention hearing. The court found that a material change in circumstances did exist, and on November 12th, a hearing was held on the motion. After oral arguments, the court ruled from the bench that there was still substantial evidence to support the charge and clear and convincing evidence that the defendant would pose a substantial danger to the community and further was a flight risk. Ms. Richins has now been held in pretrial custody for 28 months, so over 2 years. I think the second one is the one we watched. Either way, you can go back and check it out on our channel if you want to. Material change in circumstance since November of 24. So in order to even have the judge consider this, you have to show a material change in circumstances. The following circumstances have materially changed since the previous detention hearing and call for a renewed review of bail and or conditions of release in this case. New evidence has come to light that goes to the heart of the state's allegations that Miss Richins poisoned her husband with fentanyl. The state's case is based on statements made by Carmen Lauber that the state procured fentanyl from Robert Crozier on 2 occasions and sold it to Miss Richins. The defense has recently learned that in April of 25, Ms. Crozier met with the prosecutors from Summit County and informed them that this was not true. Mr. Crozier told members of the prosecution team that he did not sell fentanyl to Ms. Lauber, but rather sold her OxyContin. Although the state failed to disclose this exculpatory statement to the defense as required under Brady and Giglio, the defense still learned of it independently when they interviewed Ms. Crozier on September 3rd, 25, at which time he relayed this exculpatory information. And they also mention here in a footnote that this statement that he did not sell her fentanyl is consistent with what Ms. Lauber originally said, and then she changed to say, oh, it was fentanyl. So that's interesting too, is now the defense has multiple witnesses they can impeach with inconsistent statements. Mr. Crozier has now informed both the state and the defense that he sold only OxyContin to Carmen Lauber on 2 occasions in early 22, and they attached the affidavit we read to this motion. He further told the state and the defense that he did not recall previously telling Summit County detectives that he had sold fentanyl to Ms. Lauber, and at the time of the previous interview, he had been detoxing and was out of it. Mr. Crozier, who is now sober, states he's certain that he sold Ms. Lauber 30 milligrams OxyContin pills on both occasions. Now we get to argument. This code in Utah provides that an individual charged with or arrested for a criminal offense shall be admitted to bail as a matter of right, except if the individual is charged with a felony when there is substantial evidence to support the charge, and the court finds by clear and convincing evidence that the individual would constitute a substantial danger to any other individual or to the community after considering conditions of release that the court may impose. The individual is released on bail, or the individual is likely to flee the jurisdiction of the court if the individual is released on bail. So what they're going to focus on here is there still substantial evidence to support this charge? They are going to argue that because this change in circumstances, because of this change in statements, is there still substantial evidence to support this charge? Because they don't believe so. Although the court has previously found that there is substantial evidence to support the charges against Ms. Richins, Mr. Crozier's recantation of his previous statement changes the landscape to a degree that cannot be ignored. In order to continue to hold Ms. Richins without bail, the court must first find that there is substantial evidence to support the charge, and that simply no longer exists. Our Supreme Court has explained that the purpose of the substantial evidence standard in the bail context is to ensure that the quantum of evidence presented by the state sufficiently justifies the denial of the defendant's right to freedom from pretrial incarceration. So does this mean we no longer have substantial evidence against Kouri Richins that she actually committed this crime? And will the judge think that? It's not what's a jury going to do. It's what does the judge think about that? Pantoffel said, from a defense standpoint, could it be strategically better to put witnesses on and exploit how shaky he always was, plus how the state possibly hid recantation? So again, I don't know what the judge is going to allow you to do if you do put them on. I'd rather strike all of these witnesses that have to do with the drug dealing, because then it's like fentanyl. Kouri Richins never had fentanyl. How would she get fentanyl? And they have a good faith basis to believe that she never got fentanyl from anybody. So how would this be possible? Again, I think the state could win even without these drug dealers. They don't have to prove that she bought it from this drug dealer, right? Think about a lot of different cases. You don't have to prove where they got the weapon they committed the crime with if you can prove they committed the crime. It's obviously better. It's much better if you have it. But there are sanctions that don't lead to a dismissal, I think, that are possible for the judge. I think the judge is probably not going to go as far as I think is appropriate based on this horrible, horrible decision by the prosecutors, if in fact it comes out that it's true. Yes, everybody hit that like button. Take a second here. All right. In this matter, the state's entire theory of criminal liability is that Kouri Richins procured fentanyl from her housekeeper, Carmen Lauber, which she caused to be unwillingly ingested by her husband in some unknown way, directly causing his death. There is no physical evidence of this, but only the statements of Carmen Lauber. I mean, if I'm the state, I'm going to say his talk screen was physical evidence. I mean, there's definitely other physical evidence, but they're making their argument. There's no physical evidence of this, but only statements of Carmen Lauber. And these statements are wholly dependent on whether or not Carmen Lauber procured fentanyl from Robert Crozier. None of these so-called fentanyl pills were found nor tested. Lauber only believes she sold Kouri Richins fentanyl because she believed that is what Crozier gave her. If Robert Crozier did not in fact sell fentanyl to Lauber, there can be no credible argument that substantial evidence of guilt exists. Maybe the judge does not allow the state to even say she got fentanyl from a drug dealer, right? There are ways to do this. And since in criminal cases, a jury must find a defendant guilty beyond a reasonable doubt, the substantial evidence standard is met when the prosecution presents evidence capable of supporting a jury finding that the defendant is guilty beyond a reasonable doubt. Even though the prosecution's cases need not be airtight and the defense must do more than have poked holes in the state's case, there must be evidence that supports the elements of the crimes charged. That is not the situation before this court. If the state cannot place fentanyl in the hands of the defendant, the state has no case. That's according to the defense. And once again, it would obviously be best if they did, but they don't have to do it for the M charge. Mr. Crozier's statement doesn't just poke holes in their case, it throws a grenade into the middle of it, leaving them nothing but speculation and conjecture, getting them nowhere near the realm of beyond a reasonable doubt. A district court may not deny a defendant bail unless the facts adduced by the state, notwithstanding contradiction of them, by defense proof, warrant the conclusion that if believed by a jury, they furnish a reasonable basis for a verdict of guilt. So this language right here, okay? Yes, this is in the context of a bail reconsideration motion. And this is specifically what they're asking the court to do at this point. This language is very consistent with a motion to dismiss. This language is very consistent with higher sanctions, bigger asks than they're requesting right now. And we are going to get a little insight into what the judge is thinking if he grants bail. My opinion, still not going to grant bail. That would be my guess, is that he's still not going to grant bail. I think he might go with other sanctions to the prosecutors personally if he finds that this was an intentional burying of evidence. That's bad for them and good for the defense. And potentially, I think he may limit certain things around these witnesses or may allow the defense to dig into what the prosecution did with these witnesses. I think it is possible that he allows something like that. I think he should. Without substantial evidence to support the charge of aggravated homicide or attempted aggravated homicide, the analysis ends and Ms. Richins should be released. For the reasons stated herein, Ms. Richins respectfully moves this honorable court to reconsider its previous detention ruling and grant her the privilege of pretrial release. So we have a motion to compel saying, give us everything you wrote, recorded, conversations that you've had with Crozier. I would say with all of these confidential informants, give me everything with everything. And that I think should be granted by the judge. They're also asking for bail. I don't expect that. Gretchen said, robust cross-examination incoming. LOL. Maybe in a different courtroom. Special case said, when will the court hear this and make a ruling? Will it be streamed? I don't know when the hearing is going to be set, but I believe it will. I think the judge should find a substantial change in circumstances, which would allow a hearing. That hearing, I believe, will be streamed, although I think in this case, and we've been out of this case for a while, but I believe in this case, they are recording it and then dropping it later. Like they're recording the whole thing and then dropping it later. I don't think it's on like a 30-minute delay or something, but I could be wrong. Somebody in the chat may remember exactly how they're streaming this one, but it wasn't like a live stream. I am going to answer some questions in the chat now. You guys make sure you've already hit the like button. Make sure you get your questions in there. It's always hard when I'm reading the document to answer questions at the same time. So this gives me an opportunity to jump back in and answer them. If, hoping not, she were to get bailed, does she get her kids back? No, that would be another process and procedure that I don't think is going to happen. So no, it wouldn't automatically mean that. I'm a tad confused. How does whether or not it was fentanyl versus oxy change anything? Well, that would be like me saying somebody died from a gunshot wound and somebody said, I sold this person a firearm. And then it's actually like, oh no, actually I sold him a knife. Well, could be important because if the knife didn't cause the death, then why is that relevant that I sold you a knife sometime? Still could be like, I'm still planning and plotting to use a weapon in this scenario. So you can ask questions like that, right? But that could be why this is such a big deal. And we'll see with continued argument here. How did the defense learn about this? Ashley said, well, the defense, while prepping for trial, wanted to talk to some of these witnesses. And what did they do? Well, they're like, Mr. Crozier, can we talk to you? You're in the county jail. You're easy to find. And they're like, okay, let's talk to you about this case. So they start talking to him about it. And he's like, oh yeah, by the way, a couple months ago in April, I talked to the prosecutors and this is what I told them. And they're like, what? So that's how they found out. Not good. Not good. The fact remains, Kouri sends text to procure the fatal drug. Do you think we have seen all of the text in this case? I always assume, spicy burrito, that we have not seen all of anything in any case, right? It takes a little while for everything to come out, but usually not till trial do we really know the full crux of what's going on and what the state has in a case like this. So I don't know the answer to this question. And yes, the text messages, the letters that she wrote, the actions she took after the fact, trying to get her hands on this money. There's just so much still that makes her look so bad. But you got to play by the rules, and the rules must have teeth. They must. Laura, was reminded. Does that mean that they are lying and saying what they want him to say? So I was reminded, or I was told, or somebody said I said this. I think what those are doing, because if you remember the language in affidavits, it's usually like, this is what I believe to be true in my own memory, unless otherwise stated. That's it, otherwise stated, right? Somebody told me this. Now, I don't want to be held accountable as I'm swearing under oath, under penalty of perjury, that I actually did say this, because I was not in my right mind, but they told me I say this. It's kind of just like a qualifier, but maybe you could read it as, does that mean they forced you to, told you to lie, things like that. Also, sometimes people don't actually know what's in the pills. I agree. And they could ask the drug dealer, did you test these pills? Did you know that they were fentanyl versus this? And my guess is he would say, based on his affidavit, they look very different. These fentanyl pills were almost purple. What I was giving her was a different color blue, and those were called blues at this time in 2022, and there was Oxycontin. These darker purple blues were the fentanyl in the end of 2022. Why would the prosecution make such a bad move? They have such a good case and jeopardize setting her free. Again, this is just me assuming, because I have no idea, and I usually like to give people the benefit of the doubt, that this was a mistake. If they're going to try to say, well, we think his testimony is basically the same, that he didn't really remember what he sold her, it could have been fentanyl, could have been Oxycontin. I would not agree with that. I would not agree with that at all. I think that would be a bad move. Be more, illegal pills are highly likely to be laced with fentanyl because they are produced to look like a real prescription drug. That dealer would know that. So here's what I'll tell you this. Good argument, could be a very good point by the prosecutor. Still does not absolve them of the wrongdoing of not turning this over. And these, be more, very smart comment, because this is exactly what lawyers have to do. So now what the lawyers would do on the prosecution side is bring in an expert, talk about street drugs. Yeah, this is what they can look like. This is what they're called. This is what drug dealers do. They have sources that they get these pills from. They're not getting them themselves from a doctor. He even said he gets these from a doctor, but if he needs this type of pill, he goes to an outsourcing, and that's not exactly a legal outsourcing. So you can't necessarily trust what those pills are because they still could be fentanyl. Or, as we know, a lot of street drugs are laced with fentanyl. So it's very likely that these drugs were either laced with fentanyl, were fentanyl. He didn't know what they were. Nobody tested them, but we know that Richins got them from Lauder, who got them from Crozier, and Richins is the one that gave them to Eric Richins. You get an expert, you connect all those dots, and you still create your case and explain it to the jury. It's just a little more difficult now. It's a little more convoluted. There's a little more gray area, but you can still prove your case. That's my point. That's what makes this so bad and frustrating. Prosecutors can't do stuff like this because then we can't trust them to be administrators of justice. And if we talk about people getting wrongfully convicted and wrongfully charged and wrongfully tried, how it ruins their lives, and how it's not that hard to convict somebody as a prosecutor, whether or not you have the right guy or gal sitting there. So you have to be a line of defense. The prosecution has to be a line of defense against wrongful conviction. Cops have to be a major line of defense. Maddie said they were his prescription. Some of them were his prescription. Some of them were not. I'm just saying, sometimes you do, sometimes you don't. And if he never gave her fentanyl, then obviously he didn't give her his prescription. He gave her some drugs he got from somebody else. I thought he said when it's the lower dosage, they're his, but the higher dosage you had to get from somebody else. I can go back and look at it, but my point is you can get an expert to explain how this still works. Now, the expert might say it's possible they were laced with fentanyl, and as a defense attorney, you can have a heyday with possible. Well, anything's possible. They could have been water pills. And it's not a crime to give somebody water pills, right? Water pills can't kill anybody, right? She's also tried to take him out more than once. Yes, again, this is the context I'm discussing that the prosecution still has to build their case and explain how all this worked with circumstantial evidence. Because even that's not like an ironclad story that it was her trying to take him out in the past. Could have been food poisoning, could have been something upset his stomach, could have been an allergy, right? Could have been a lot of things. But again, the full picture that the state's going to be able to build here. Yeah, Ashley, this was my memory as well, but we just read it and I've been reading and doing a lot of things here. Wouldn't this ultimately be a jury finding since the female dealer is still on the record saying she sold Kouri fentanyl? Absolutely not. Did the prosecutors screw up and not turn this over? That's absolutely not a jury finding. But if you're asking Laura, if it's fentanyl versus OxyContin, was Kouri Richins trying to procure drugs to poison Eric Richins? Yes, that could absolutely and should absolutely still be a jury question, which is why the prosecutor just deals with this issue. They make the argument to the jury. They explain to the jury why they should see it their way. So yes, great question, Laura. So this is going to be really interesting. This case, I think this is going to be a major ripple effect in the case and is going to change the way a lot of witnesses testify in trial. Maddie, no big deal. I could have been wrong. I could have been wrong just as easily as you were. We're all kind of thinking about this in real time. So no big deal. I'm glad you brought that up. And thank you, because that would make a difference. If I get it directly from my doctor, it's not going to be laced with fentanyl. Sure hope not. So also today, earlier, a bunch of people were sending me the Mark Sanchez civil lawsuit and asking how is this happening so quick and why is Fox involved? Should they even be involved? And I've recorded a quick video on that we're going to automatically redirect you in. So if you have autoplay on, click it. It's right by kind of like the settings gear. Click autoplay. You'll immediately, when this video ends right now, be kicked into that chat in that room to watch that. Because if you have a question as to how he possibly got the civil lawsuit, the victim in Mark Sanchez's case, filed this quickly, and how Fox could possibly be liable for something like this, well, we've got the video for you. A bunch of people, even reporters and stuff, have been calling me today about this specific case. So I figured my people here, you guys, might also be interested in it. So that's why I wanted to record something, get it out to you. And I didn't have time to do an extended long live today. So make sure you guys hit the like button here and hit the like button there. Make sure you're subscribed to our page so you don't miss any uploads that we have. I appreciate you guys so much for being here with me. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.